The defendant, Simon Haye, is 54 years old. He falls to be sentenced for the rape of a woman 23 years ago in November 2002. He has refused to leave his cell at Lamoy prison today. Accordingly, he is absent from court, but he is represented by his advocate. His advocate has addressed us on behalf of the defendant, so we are proceeding to sentence. The time of the rape, the defendant was 31 years old and his victim was 17. The defendant had been in a short relationship with the victim in the period leading up to the rape. It was a relationship characterized by the defendant harassing, manipulating, and threatening his victim. The rape resulted in a pregnancy and subsequent miscarriage. The defendant was convicted by the jury and does not benefit from the substantial discount that accompanies a guilty plea. When the defendant raped his victim, she was still at school. She had one particular friend, her best friend, with whom she shared her secrets. Both the victim's best friend and the victim's mother gave evidence during the defendant's trial. We do not name the victim or the victim's friend or the victim's mother, so as to ensure the victim cannot be identified. As the victim of a sexual offence, she is entitled to lifelong anonymity. In September of 2002, the victim and her friend met the defendant when he was at the harbour fishing with another man. The victim thought the defendant was a nice person. Later on that evening, they met the defendant outside a public house in town. The defendant learned from the victim and her friend that they were not permitted in the public house in question, as they were just 17 years old. During this conversation, the defendant lied to his victim, saying he was 25 years old. She subsequently discovered he was 31. Shortly thereafter, the victim and the defendant began what the Crown describe as a casual relationship. The relationship lasted 2 or 3 months. From time to time, they would meet up. The victim would come to the defendant's flat and they would engage in consensual sexual intercourse. During the course of the relationship, the defendant's behaviour towards his victim became domineering and unkind. The victim did not tell her family about the relationship, and they never met the defendant. In her evidence to the jury, the victim said that when she met the defendant, she was a happy-go-lucky girl who had had a fantastic upbringing and a wonderful childhood. The victim grew up in a close-knit and religious family. She was enjoying life at school and had a strong relationship with both her parents and also many friends, including her best friend, to whom we've just referred. She told the jury that there was nothing remarkable or sinister at the beginning about the relationship with the defendant. Over time, this changed. The defendant began to send threats via mobile phone message to his victim, saying he was going to go to her father's place of work to tell him that she was a slag. He accused her of sleeping with somebody else when she was not. She told the jury, "I did not want to believe the sinisterness of it at that point in time." On one occasion, at 11 o'clock at night, when the victim was driving home with her best friend in her best friend's car, the defendant overtook them on his moped, forcing their car to stop in a bus stop. The two young women had to ask the defendant not to follow them. The defendant became obsessed with the victim ending the relationship. One day when the victim was at home, she received a text from the defendant saying he was outside her house on his moped. She looked out of the window, and there he was. The defendant told his victim that if she did not speak to him, he would either kill her family or go to her father's place of work to tell him that she was a slapper. The defendant asked his victim to flash her breasts at him, which she did. Then the defendant went home, but he came to her house and waited outside on many subsequent occasions. By now, the victim had begun to become concerned. She said, "By now it was a bit strange. I thought I could make things better. I could talk it away if I could keep being nice." Early on in the relationship, the defendant told his victim that he was a diabetic. On one occasion, he tried to harm himself in order to secure her sympathy. The defendant phoned his victim and asked her to come round to his flat, which she did. There she found him drinking a litre bottle of an Alco-Pop. The defendant told his victim he should not be drinking because of his diabetes. She was worried about him having a fit and injected him with insulin. As the relationship went on, the defendant began to follow his victim. Wherever she was, he would appear. In evidence to the jury, the victim's best friend said that at the outset of the relationship with the defendant, the victim was funny, energetic, relaxed, and the defendant was not a big deal. She said that she saw her friend, the victim, change massively during the course of her relationship with the defendant. And by the end, the victim was petrified of him. This was because he was stalking and harassing her. The friend gave evidence of various incidents which directly supported the victim's account. On one occasion, after an evening in town, the victim and her friend went to the victim's car to find that the rear tyre had been slashed. The defendant happened to be there to help change the tyre. The victim's best friend thought the defendant had probably slashed the tyre himself in order to appear to be heroic. She told the jury that he was desperate to have the victim as his girlfriend and that she seemed to be the biggest thing in his life. She expressed the view that he must have spent a lot of time finding out where the victim was. The victim's best friend said that the victim had a lovely family, but they had very religious views, and this was something that the defendant knew and used to manipulate her. She described the defendant in these terms. She said, "His tactics were coercive and manipulative. Do this or I will hurt you and the people you love." The best friend said that the victim did not want her parents to find out about the relationship she had with a much older man. And the defendant used this to his advantage. For example, making threats to go to her father's workplace, to which we've just referred. One of the most unpleasant incidents took place during a telephone call towards the end of the relationship, when the defendant falsely suggested that he was in the process of taking an insulin overdose. The victim was speaking to the defendant on his mobile telephone. During the call, he threatened to kill himself unless the victim committed to the relationship. The victim implored the defendant not to do so, saying he had things to live for. The victim was so concerned by what he was saying that she got hold of her best friend on the landline at the same time. An overdose of insulin can be very dangerous, and the defendant told his victim that he was a type 1 diabetic. During the phone call, the defendant pretended he had stopped breathing as a consequence of the overdose he had pretended to take. The victim told the jury the defendant was breathing heavily on the call, and then he stopped breathing altogether. The victim phoned her best friend and said words to the effect the defendant was taking his life. Her best friend recalled the phone call as well, and she phoned for an ambulance. Paramedics rushed to the defendant's flat and discovered he was fine. But the victim thought he had died. This was a cruel trick and a compelling and extreme example of controlling behavior and emotional manipulation. This incident occurred just a few weeks before the defendant raped his victim. The victim told the jury there were many occasions on which the defendant threatened to kill himself if she left him, and told her that it would be her fault if he did so. She told the jury, "I believed every threat he made because of the way it was said." And she told the jury that by this time, "I was exhausted. It was so tiring. I was waiting for the next thing to happen. At the beginning of November, it was at its worst. I would go round to his house because of abject fear." By the 5th of November of 2002, the victim was in fear of the defendant. She told the jury she was capitulating to everything. She was worried the defendant was either going to kill her, or himself, or her friends, or her family. On this day, the defendant telephoned his victim, telling her he wanted her to visit him in his flat one final time, to say goodbye and have one last cuddle, after which he would not bother her anymore. She believed the defendant and agreed to do this. When the victim came to the defendant's flat, he apologized for his behavior. She followed him inside and agreed to go to his bedroom and agreed to a cuddle. When he asked her to remove her clothes for the purpose of a hug in the defendant's bed, she did, believing that if she agreed, he would leave her alone. In fact, he flipped her onto her back, pulled her legs up, pinned her down with his body, used one of his arms to hold her limbs, and placed the other on her throat. She could not move because of the weight of the defendant's body. The defendant then raped her. She told him to stop at least 3 times, but he ignored her. Prior to this occasion, it had always been agreed the defendant would wear a condom during consensual sexual intercourse or withdraw prior to ejaculation. This time, he did neither. The rape ended with the defendant ejaculating inside his victim. Immediately afterwards, the victim got up and began to get dressed. She left the defendant's flat in shock. Within a day or so, she felt able to tell her best friend that she'd been raped by the defendant, but was unable to tell her family at that stage. She'd also been told by the defendant about his previous conviction for rape, and he told her he'd been wrongly convicted and that he was innocent of that charge. She told the jury, "He was very convincing. He told me that his life had been ruined. I felt sorry for him." A couple of weeks later, the night before her 18th birthday, the victim told her best friend that she thought she might be pregnant. That night, they went out in St. Helier. The defendant appeared uninvited towards the end of the evening and produced a cigarette packet when the victim and her best friend were together in the street with the words, "I will kill you all," written upon it. The victim asked her friend to call the police, which she did. The victim was crying and upset. By now, both the victim and her friend were scared of the defendant. Shortly afterwards, the victim took a pregnancy test, which confirmed her feelings. Owing to her and her family's belief, termination of the pregnancy was out of the question. She told the defendant that she was pregnant. He was pleased, and they both went to see a doctor together. The victim was referred to hospital for a scan, as it may have been an ectopic pregnancy. The defendant went with the victim, but there was something about his demeanour that led to the person operating the scan to ask him to leave the room, which he did. A few days later, the victim suffered a miscarriage. She told her mother what had happened, that she'd been raped by the defendant. Her mother described the victim as sobbing and shaking. The mother took her daughter, the victim, to their family doctor, and he noted in his records the victim was having a miscarriage of a pregnancy following non-consensual sex. After the miscarriage, the victim was signed off school for 10 days and stayed at home. On the 31st of December, the defendant telephoned the victim and said, "I should never have done this to you. Everything I have done is awful." The victim reported the defendant to the police in 2023. She had returned to live in Jersey not long before this date and was concerned that she might see the defendant again, and was concerned about her children growing up in an island where the defendant was at liberty. The defendant was arrested and interviewed. He made no comment answers to most of the questions. As to the pregnancy, he said, "As far as I knew, she had an abortion." The defendant falsely claimed that the victim had told him that her parents had forced her to have a termination of the pregnancy, which was a lie, that after that they'd fallen out and gone their separate ways. These were, of course, unpleasant remarks to make, the defendant well knowing the views the victim and her family held in relation to termination of a pregnancy. When the defendant was arrested, his electronic devices were seized and downloaded. Many images and videos of rape pornography were found, with the first known date for content of such pornography being downloaded being August 2010, and the last known search for such material being in December of 2023. Although this material was extreme in content, it is lawful to possess, and that is why there are no separate charges in relation to this material. The defendant did not give evidence at his trial, but he filed a defence case statement in which he made allegations as to his victim's mental health and suggested she may have had a financial motive for making the complaint that she did. The defendant claimed through his counsel at trial that the victim had convinced herself that consensual intercourse with him had been rape. This was rejected by the jury when they found the defendant guilty in October. In the recent case of Attorney General and Roberts, 2025, the superior number of the Royal Court set out a framework for the approach to rape sentencing. That approach was subsequently approved by the Court of Appeal. That approach requires the court to analyse the culpability of the defendant and the harm caused by his actions so as to arrive at an initial point for the sentence, which will then be adjusted by reference to aggravating and mitigating factors. At that stage, the court will consider whether the sentence is appropriate, having regard to all the circumstances of the case. In Roberts, the court noted that the Attorney General proposed that in a case involving a single offence of rape, with the presence of one harm or culpability factor, an initial or starting point of 7 to 9 years imprisonment might be appropriate. Cases with a combination of such factors or the extreme nature of any harm factor may merit an initial or starting point of 10 to 12 years imprisonment. Some cases would warrant an initial or starting point of 15 years imprisonment or higher. The court in Roberts, at paragraph 90, said that while not dismissing the Attorney General's proposed ranges as beginning the sentencing process, it did not feel bound to follow them. In this case, the Crown used the proposed ranges as a means to identify the initial point, which, on the facts of this case, we regard as appropriate. It is noted from the decision of the Court of Appeal that the approach in Roberts was limited to offences arising from the rape of an adult. The defendant's victim in this case was not an adult. She was 17, but not far short of her 18th birthday. Nonetheless, we feel able to use the guidance in Roberts, although generally, where the victim is a child, particularly a child below the age of 16, longer sentences may be appropriate than those suggested in Roberts. Upholding the decision of the Royal Court in Roberts, the Court of Appeal noted at paragraphs 155 to 157 that the Royal Court is entitled to have regard to the English Sentencing Council guidelines as a cross-check the jurists may wish to employ to inform, test or confirm their opinion if they think appropriate to do so. Those guidelines are not binding and need not be followed, but as the Court of Appeal said in Roberts, they may be used as a cross-check. It was not necessary for us to refer to those guidelines today. Applying the schedule to the decision of the Royal Court in Roberts, the Crown has identified, and we accept, the existence of the following factors relevant to the harm which flowed from the defendant's offending. First, as a consequence of the deliberate decision of the defendant to both rape his victim and ejaculate inside her, she fell pregnant, subsequently suffering a miscarriage. It is well established that pregnancy consequent upon rape is a factor the court should take into account as affecting the initial point for sentence. Further, the victim has struggled throughout her adult life with the loss of her baby. The victim has had the courage to read her victim personal statement to the court today. We do not repeat the entirety of her statement, but on this particular matter, we cannot articulate things better than she did when she said this: "The worst part is that I have a deep-rooted guilt and pain in terms of my baby that I lost. Even though the baby was conceived in the worst of circumstances, my beliefs still conflict with my feelings that I wish the baby would never be born because of Haye. I feel deep sorrow and regret that I wish the baby to be not born, and I'm even more saddened by the fact that the baby was lost. To this day, I still visit the Overdale Memorial Baby Garden on what my due date would have been every year. This is never going to get any better. The aftermath is harrowing, and will stay with me as long as I live. The second feature arising from the harm caused to the victim, relevant to the initial point for sentence, is the fact that she suffered extreme psychological harm, as independently evidenced by Dr. Connor, a consultant clinical psychologist. Much of the report he has prepared contains personal and sensitive information as far as the victim is concerned, and we do not propose to repeat it. The victim's description to Dr. Connor of the rape, in Dr. Connor's words, captured the terror and disassociation that commonly accompanies traumatic violation. During the rape, the victim thought that she was going to die. To this day, she is unable to wear clothing around her neck due to the memory of the defendant placing his hand around her throat over 20 years ago. She experiences chronic hypervigilance, disassociation, intrusive thoughts and imagery, nighttime rituals, avoidance of darkness, and a sense of living under constant threat. She has now experienced this for approaching 25 years. Indeed, she said to us towards the end of her statement, at some point every single day for 25 years, a memory has triggered part of what happened and brought it all back. Through this, I have served a life sentence for what he did. As to the defendant's culpability for this offending, we agree with the Crown that we not only ought to, but we must take into account the sustained period of ill treatment of the victim prior to the offence, amounting to a campaign of emotional abuse and manipulation, leaving the victim extremely fearful of the defendant at the time of the offence. It was argued on the part of the defendant today through his counsel that we should not regard these matters as relevant to the defendant's culpability, as the defendant's conduct was not designed to facilitate the offence of rape. We disagree. The effect of the defendant's ill treatment towards the victim left her in the state of fear that she described on the 5th of November 2002, where she was, in her words, capitulating to everything, including the request that she go to the defendant's flat, remove her clothes, and climb into his bed, where she was raped. His conduct on the day of the rape was also indicative, in our view, of a significant degree of planning, also a factor relevant to an offender's culpability. But if we're wrong on that matter, then in any event, the extremity and the severity of the harm factors to which we referred justify an initial or starting point of 10 to 12 years imprisonment, and the defendant's conduct and treatment of his victim prior to the offence we would treat as aggravating his sentence in any event. The Crown suggests an initial period of 10 years imprisonment. In our view, the initial period should be no less than 10 years imprisonment. As to the aggravating factors which are listed at Schedule 3 to the judgment in Roberts, the substantial and significant aggravating feature in this case is the defendant's previous conviction for rape in 1995. For that offence, he was sentenced to 9 years imprisonment. He was released from custody on the 20th of November 2000 and raped his victim within 2 years of release. The circumstances of that rape were themselves extremely serious. At 1:30 a.m. on the 3rd of September, 1994, the defendant dragged a total stranger into a car park in St Helier and held her there for an hour. He put his hand over her mouth and nose and squeezed her throat to the extent that she was unable to breathe and thought she was going to die. He forced her to suck his penis and inserted his fingers into her anus and vagina. He then raped that victim, leaving her naked to the waist. She ran into the street and stopped a taxi driver who drove her to the police station. Again, the defendant was convicted after a trial. There is no mitigation available today to this defendant in respect of the offence that is before us. He refused to engage with the probation officer, so we have no pre-sentence report. The defendant met his victim less than 2 years after he'd served a 9-year sentence for rape. At the time he met her, he was 31 and she was 17. In the course of 3 months, the defendant manipulated her, destroyed her self-confidence, and left her vulnerable. He lied to her repeatedly and intimidated her. The manipulation and threats culminated in the defendant raping his victim, as a consequence of which she fell pregnant and subsequently miscarried. The defendant was prepared to risk his school-age victim having to carry, give birth to, and raise a child born of sexual violence. He has not admitted his guilt and therefore deserves no credit for admissions, remorse, or a guilty plea. The Crown moves for a sentence of 11 years imprisonment. Having regard to all the circumstances of this case, the sentence of the court is 12 years imprisonment, which we feel adequately reflects all the matters to which we've referred. Furthermore, the defendant is now subject to notification requirements under Article 5 of the Sex Offenders Jersey Law 2010. We must fix a minimum period, and it's only after expiry of that minimum period the defendant is entitled to make an application to be removed from the Sex Offenders Register. Bearing in mind the circumstances to which we referred and the term in custody the defendant will serve, we fix that period as 20 years. We also make a restraining order under Article 8 of the Crime Public Order Jersey Law 2024. It's accepted that the criteria for making such an order are met in this case. We make such an order without limit of time. We extend the order to protect not only the victim, but also her husband and her children. Accordingly, the defendant is prohibited from approaching or contacting directly or indirectly or going near the home or work address of the victim and her family for the rest of his life. We make the order sought by the Crown at paragraph 52 of the conclusions. That completes our remarks. Anything else, Hollywood?
No, sir.
Harrison?